Hey everyone, it's Dawn here. I hope I'm finding you well. I'm here to just take a look at the new filing. Richins has been charged with multiple financial crimes in a brand spanking new case. It will not be part of her case that's happening next year regarding her charge of murder of her husband, Eric Richins. This is a separate and new case. So I thought we could just look at the filing together. So before we start, in case you haven't heard, there are 26 new federal charges, and these are relating to financial activity of Kouri Richins just prior to Eric's death, her husband's death. There's 5 counts of mortgage fraud, 5 counts of forgery, and these two go hand in hand in this case. The forgery and the mortgage fraud, the dates are exactly the same. There are 7 counts of issuing a bad check and 7 counts of money laundering, which also go hand in hand together, the issuing of bad checks and money laundering, if you look at the dates, which we'll get into. And more summary charges. There's a count of communications fraud, and a count of of unlawful activity. And that is putting it lightly, right? If you're familiar with all of the things that she has done, allegedly, regarding not just financial crimes, but criminal crimes, violent crimes. So these 26 felony charges against Kouri Richins are all uh, activities that took place in Summit County, Utah. So in the same place. She hasn't been flying around the world or anything. It's all right there in tiny little beautiful Summit County, Utah. If you haven't been there, you should recommend traveling there. It's just gorgeous summer or winter for skiing. So again, there's mortgage fraud. That's 5 counts. She's basically accused of making misstatements or omissions during a mortgage lending process 5 different times with intent to defraud, and these amounts exceed $5,000. We'll get into the particulars when we read the actual filing. 5 counts of forgery. She's accused of making fraudulent writings with the intent to defraud. This is third degree. The mortgage fraud 5 counts are second degree. She has 7 counts of issuing of bad checks. Some are $1,500 or more, and some are more than $5,000. So third and second degree on those 7 charges. And then money laundering, 7 counts. So she's accused of conducting transactions involving proceeds from unlawful activity with the intent to promote that activity. So that's what money laundering is defined as. So broadly. And then communications fraud, which is interesting. She's accused of devising a scheme to defraud and communicating for the purpose of executing or concealing that scheme, and this is also for an amount over $5,000. And this is my favorite: pattern of unlawful activity, 1 count. So she's basically accused of receiving proceeds from a pattern of unlawful activity. So let's get into it a little bit before we get to the reading. Um, I'm not going to read every single count. It's a 26 total because there's so much repetitiveness apart from maybe the date. So I'm going to read the definition as written in the filing for each of the separate counts that are unique. So the 5 counts of second degree mortgage fraud, where the value of the property, money, or thing obtained or sought to be obtained exceeds $5,000, that's a second degree felony. And all of these again took place in Summit County. It says the defendant did, with the intent to defraud, knowingly make a material misstatement, misrepresentation, or omission during the mortgage lending process. intending that it be relied upon by a mortgage lender, borrower, or any other party to the mortgage. So that's the mortgage fraud, 5 counts of that, just different dates. And those are all second degree. And the second degree generally refers to the amount of the fraud, like the value, the financial value, monetary value. So then there's 5 counts of third degree forgery. And they define that as that she did this with the purpose to defraud someone, make, complete, execute, authenticate, or utter in writing a writing so that the writing or the making, completion, execution, authentication, or utterance purports to be the act of another person, whether that person is existent or non-existent. So that's what forgery is. In this case, third degree. And in this case, 5 different counts, 5 different dates. Again, those dates go hand in hand with the mortgage fraud counts. So there's 7 counts of issuing a bad check, 4 are third degree, and 3 are second degree. So the difference is for third degree, it's at least $1,500, but less than $5,000 in terms of the monetary value. And for second degree, the check made exceeds $5,000. So 4 counts of third degree and 3 counts of second degree, again on 7 different dates. So let me read what it says that she's being charged with or accused of. For the third degree felony, as follows, to wit, the defendant did issue or pass a check for the payment of money for the purpose of obtaining from any person, firm, partnership, or corporation any money, property, or other thing of value, or paying for any services, wages, salary, labor, or rent. The defendant knew the check would not be paid by the drawee. Payment was refused by the drawee. The check made or drawn in the state of Utah is or exceeds $1,500, but is less than $5,000. And then for the second degree, they all read the same thing except for the dates. Issuing a bad check. Second degree, basically same wording as what I just read. However, the last line is that the check made or drawn in the state of Utah is or exceeds $5,000. So it's the monetary value in that case for those charges that define second, third, first degree. So now we get to money laundering. 7 counts of second degree money laundering. Apart from dates, these all read the same thing. Second degree felony as follows, to wit, for money laundering in Summit County, state of Utah. Again, the defendant did conduct a transaction knowing that the property involved in the transaction represents the proceeds of some form of unlawful activity with the intent to promote the unlawful activity. So that's how those 7 counts are defined. Again, all Kouri Richins in Summit County, just separate dates. Now, the money laundering and the issuing of the bad checks also go hand in hand. If you look at and we'll scroll through the actual filing in a few seconds here, but those dates also go hand in hand. So she was writing the bad checks with the intent and money laundering with those checks. Just lovely. So then there's 2 more charges. So that totaled 24. So it was 5 counts, 5, 7, and 7 in varying degrees. And then we have 1 count of second degree communications fraud. So communications fraud is a second degree felony in this case, as follows, to wit, that the defendant did devise a scheme to artifice or defraud another or to obtain from another money by means of false or fraudulent pretenses, representations, promises, or material omissions, and communicated directly or indirectly with any person by means for the purpose of executing or concealing the scheme or artifice. The value of the money, property, or thing obtained or sought to be obtained is or exceeds $5,000. So that's communications fraud. So basically, she communicated directly or indirectly in order to execute her scheme. And that's what that count is for. These are all felonies. And then the last one is one count, a pattern of unlawful activity. And this is in the second degree as follows: to wit, that on or between June 29th, 2021, these are important dates, and March 3rd to 4th, 2022, in Summit County, the state of Utah, the defendant did commit prohibited conduct concerning a pattern of unlawful activity by receiving proceeds derived, whether directly or indirectly, from a pattern of unlawful activity in which the defendant has participated as a principal. And as we know, Eric died on March 4th, 2022. So these activities that are outlined in this filing start in June of 2021, and they go on through Eric's death on March 4th, approximately. So let's read the actual summary. Hold on a second, let me grab that document. So the background by which all of these charges are filed. So this information, these 26 charges, this information is supported by the following probable cause statement. So this is the background to support all of those 26 charges. The defendant met Eric Richins in 2009 while she was working as a cashier at Home Depot. They had a child in 2012 and married in 2013. At the time of the marriage, Eric Richins and his business partner owned a successful stonemasonry business called C&E Stone Masonry, LLC. Eric Richins and the defendant entered into a premarital agreement whereby the defendant released and relinquished all right, claim, or interest in C&E. The PMA provides that following Eric Richins' marriage to the defendant, C&E shall nevertheless remain the sole property of Eric Richins. The PMA further provides that the defendant shall have no right or claim to the business, except that if Eric Richins should die prior to the defendant while the two are lawfully married, Eric Richins' partnership interest in the business shall transfer to the defendant. In early 2019, the defendant used a power of attorney to obtain a $250,000 home equity line of credit on Eric Richins' premarital home without his knowledge. On April 26, 2019, the defendant formed Kouri Richins Realty, LLC, for the purpose of buying and selling real estate. The defendant was the sole member of the company. The defendant used the proceeds from the HELOC, the line of credit, to initially fund Kouri Richins Realty and hard money loans to finance its ongoing operations. Eric first learned of the HELOC line of credit, I think I'll say in the future, in October of 2020. The secret origination and continued existence of the line of credit was a source of tension between the defendant and Eric Richins. The defendant informed Eric Richins that she would repay the loan and led Eric Richins to believe that she had repaid it. The line of credit was not paid off on the day of Eric Richins' death. Oops, I went too far. Okay. Okay. On October 13, 2020, Eric Richins consulted an estate planning lawyer. Eric Richins informed his lawyer that he wanted to protect himself in the short term from recently discovered ongoing abuse and misuse of his finances by the defendant, and to protect his three children. Okay, this is very strange. Okay. And to protect his three children. Sorry, my scrolling is kind of sort of lame here. In the long term, I might have to reread that. By ensuring that the defendant would never be able to manage his property after his death. So let me just reread that. Sorry about that. Eric Richins consulted an estate planner lawyer. Eric Richins informed his lawyer that he wanted to protect himself in the short term from recently discovered and ongoing abuse and misuse of his finances by the defendant, and to protect his three children in the long term by ensuring that the defendant would never be able to manage his property after his death. On November 3rd, 2020, Eric Richins executed several estate planning instruments, including a healthcare directive, durable power of attorney, pour over will, the Eric Richins Living Trust, and each of these instruments he appointed his sister, Kouri Richins Benson, his agent, fiduciary, or trustee to the intentional and purposeful exclusion of the defendant. He transferred his home and his interest in C&E to the trust. Eric Richins removed the defendant as beneficiary of the $500,000 New York Life Insurance Company policy on his life and designated the trust as the beneficiary. The defendant did not understand this estate plan until after Eric Richins' death. In the 5 months prior to Eric Richins' death, Kouri Richins Realty realized $170,000 revenue, while its monthly debt service exceeded $250,000. It borrowed from over 25 lenders to support itself and service its debt obligations. Despite Kouri Richins Realty existing debt and insufficient revenue, the defendant continued to use hard money loans to purchase 3 additional properties in November of 2021. When the defendant closed on the 3 properties on November 30th, 2021, she added $1.1 million of high interest debt to her already staggering and unserviceable debt load. By that day, she had already defaulted on one loan and was delinquent on several others. She continued efforts to borrow from new high interest lenders to meet her existing obligations. By the end of 2021, the defendant stood on the precipice of total financial collapse. On December 23rd, 2021, the defendant contracted to purchase an unfinished mansion in Midway, Utah, using $2.9 million of high interest debt due in 6 months. And even though she lacked the financial ability to service the additional debt, refinance the debt, rehabilitate the property, or otherwise dispose of the property. The defendant was scheduled to close on the property on March 4th, 2022, the day of Eric Richins' death. She ultimately closed on it the next day. On the day of Eric Richins' death, Kouri Richins Realty owed hard money lenders at least $1.8 million. And the day after Eric Richins' death, it owed them nearly $5 million. Oops. At the time of Eric Richins' death, at least 3 insurance policies on Eric Richins' life existed with aggregate death benefits of $1 $1,350,000 and the defendant as the beneficiary. A fourth policy existed with the death benefit of $500,000. The defendant mistakenly believed that she was the beneficiary of that policy as well. A fifth policy existed that paid approximately $168,000 toward the balance of Eric Richins' mortgage. At the time of his death, Eric Richins' estate was worth approximately $5 million. The defendant, her family, K. Richins Realty, and C&E banked with America First Credit Union. The defendant also had a personal checking account with Navy Federal Credit Union, which included a $15,000 line of credit line. On July 2nd, 2021, while processing the mortgage loan, an Iron Bridge representative noted to the defendant, "When I ran your credit, it was lower than I expected. It looks that there are some delinquencies with regards to a few credit cards. I was just a bit surprised by that. I know you have a lot of money in the bank to cover expenses." 3 days later, the defendant explained, "I recently learned about all of this as well, LOL. And then my husband tried to explain to me this was his doing a while ago. We're in the process of a separation for one of many reasons, but this is one of them, to keep it short and sweet, LOL. It's been crazy to say the least." There's no evidence to suggest that this explanation is true. Subheading: the defendant submitted a falsified bank statement to Boomerang Finance in support of a mortgage loan application. And this is referring to counts 2, count 7, and count 26. On August 4th, 2021, the defendant, on behalf of K. Richins Realty, entered a mortgage loan with Boomerang Finance. On August 2nd, 2021, in support of the loan application, the defendant submitted a purported America First statement for K. Richins Realty dated June 30th, 2021, showing an account balance of $702,831.96. K. Richins' actual America First statement dated June 30th, 2021, shows an account balance of $15,339.12. C&E's America First statement dated June 30th, 2021, shows an account balance of $702,831.96. The transaction descriptions listed on the purported statement that the defendant submitted in support of the mortgage loan application are identical to the transaction descriptions listed on C&E's statement. The purported statement that the defendant submitted is comprised of the header K. Richins Realty's actual statement and the body of C&E's statement. Okay, sorry, my scrolling is so slow. So the next subheading reads, the defendant submitted 3 falsified bank statements to Excel Financial Services in support of a mortgage loan application. These are referring to counts 3 to 4 and 5, 8, 9, and 10, and count 26. In August of 2021, the defendant, on behalf of K. Richins Realty, applied for a mortgage loan with Excel Financial Services. On August 12, 2021, in support of the loan application, the defendant submitted a purported America's First statement for her personal account dated July 31st, 2021, showing an account balance of $694,730.15. The defendant's actual America First statement dated August 1st, 2021, shows an account balance of $1,893.94. C&E's America First statement dated January 31st, 2021, shows an account balance of $694,730.15. $730.15. The transaction descriptions listed on the purported statement that the defendant submitted in support of the mortgage loan application are identical to the transaction descriptions listed on C&E's statement. The purported statement that the defendant submitted is comprised of the header of the defendant's actual statement and the body of C&E's statement. Excel's representative asked the defendant for a letter explaining her low credit rating. On September 12, 2021, the defendant wrote that her low credit rating was because of a lady out of Seattle that had gotten a hold of her social security number. There is no evidence to suggest that this explanation is true. On October 13, 2021, in further support of the loan application, the defendant submitted a purported America First statement for her personal account dated September 30th, 2021, showing an account balance of $169,442.28. $169,442.28. The defendant's actual America's First statement dated October 1st, 2021 shows an account balance in the red of $4.01, negative $4.01. C&E's America First statement dated September 30th, 2021 shows an account balance of $169,442.28. The transaction descriptions listed on the purported statement that the defendant submitted in support of the mortgage loan application are identical to the transaction descriptions listed on C&E's statement. The purported statement that the defendant submitted is comprised of the header of her actual statement and the body of C&E's statement. On November 23rd, 2021, in further support of the loan application, the defendant submitted a purported Kouri Richins Realty America First statement dated October 31st, 2021, showing an account balance of $57,811.42. Kouri Richins' actual America First statement dated October 31st, 2021, shows an account. Shows an account balance of negative $1,684.75. So in the red, so less than zero. Kouri Richins' Realty statement dated August 20th, 2021 shows an account balance of $57,811.42. Transaction descriptions listed on the purported statement that the defendant submitted in support of the mortgage loan application are identical to the transaction descriptions listed on Kouri Richins' Realty August statement. The purported statement that the defendant submitted is comprised of the header of Kouri Richins' Realty October statement and the body of its August statement. This is weird. This is really strange. Sorry, I'm having difficult time scrolling. Okay. The next subsection, the defendant issued a series of bad checks and laundered money, counts 11 through 24. So that's like 13 counts plus count 26. On August 28th, 2021, the defendant wrote check number 271 from her Navy federal account to Kouri Richins Realty for $2,100. At the time, Navy federal account balance was zero. At the time of line of credit was negative $13,694.50. The defendant deposited the check into Kouri Richins Realty America First account. At the time, the America First account balance was $9,000. $139.23. The defendant then transferred $2,500 from America's First account to her mother and $13,775 to several creditors before America First could draw back the $2,100. America First ultimately returned the check for insufficient funds. On October 12, 2021, the defendant wrote check number 304 from her Navy Federal account to Kouri Richins Realty for $2,500. At the time, the Navy Federal account balance was zero and the line of credit was negative $14,952.22. The defendant deposited the check into Kouri Richins Realty's America First account. At the time, the America First account balance was $505.49. The defendant then transferred $2,518.10 from the America's First account to several creditors before America First could draw back the $2,500. America First ultimately returned the check for insufficient funds. On November 11, 2021, the defendant wrote a check number 241 from her Navy Federal account to Kouri Richins Realty for $3,000. At the time, the Navy Federal account balance was zero and the line of credit was negative $14,981.22. The defendant deposited the check into Kouri Richins Realty's America First account. At that time, the America First account balance was negative $2,231.39. The defendant then transferred $1,000 from America First account to her mother and $2,000 to her personal account before America's First could draw back the $3,000. America's First ultimately returned the check for insufficient funds. On November 12, 2021, the defendant wrote check number 275 from her Navy Federal account to Kouri Richins Realty for $5,000. At the time, Navy Federal account balance was zero and the line of credit was negative $14,981.22. The defendant deposited the check into Kouri Richins Realty America's First account. At the time, the America's First account balance was $575.39. The defendant then transferred $1,000 from the America's First account to her mother and $2,000 to her personal account before America's First could draw back the $5,000. America's First ultimately returned the check for insufficient funds. On December 20th, 2021, the defendant wrote check number 293 from her Navy Federal account to herself for $4,000. At the time, the Navy Federal account balance was negative $51.41, and the line of credit was negative $14,565. The defendant deposited the check into her personal America's First account. At the time, the America's First account balance was negative $586.76. The defendant then transferred $2,215 from the America's First account to her mother before America's First could draw back the $4,000. America First ultimately returned the check for insufficient funds. On December 20th, the defendant wrote a check number 294 from her Navy Federal account to herself for $10,000. At the time, the Navy Federal account balance was negative $51.41, and the line of credit was negative $14,565. The defendant deposited the check into Kouri Richins Realty America's First account. At the time, that America's First account balance was negative $1,033.99. The defendant then transferred $9,592.33 from Kouri Richins Realty America's First account to several creditors before America's First could draw back the $10,000. America First ultimately returned the check for insufficient funds. On December 22nd, 2021, the defendant wrote check number $343, check number 343 from her Navy federal account to herself for $10,000. At the time, the Navy federal account balance was negative $51.41, and the line of credit was negative $14,565. The defendant deposited the check into her personal America's First account. At the time, the America First account balance was $998.24. The defendant then transferred $10,000 from her personal America's First account to her family's America First account before America First could draw back the $10,000. America First ultimately returned the check for insufficient funds. Next subcategory, the defendant fraudulently extracted $45,000 from her best friend, counts 25 and 26. In late 2021, Kouri Richins Realty owned a home at 299 East 100 South in Heber City, Utah, on which the defendant owed $456,500 in 4 short-term, high-interest, hard money loans. 3 of the 4 notes secured by this property matured on January 7th or 8th, 2022. Beginning in October 2021, the defendant unsuccessfully tried to refinance that property into a traditional 30-year mortgage. She planned to then seller finance the property for her best friend. The best friend, her husband, and 3 small children moved into the home. The defendant and her best friend signed a residential lease agreement with the option to purchase, wherein the best friend agreed to pay defendant $2,900 per month in rent with an option to buy the home for $490,000. On January 11th, 2022, the defendant's best friend caused 2 wires totaling $45,000 to transfer into Kouri Richins Realty account. Correspondence between the defendant and her best friend establishes that the defendant agreed to apply this money as a down payment on a long-term mortgage, supposedly closing on January 18th, 2022. Immediately prior to the best friend's wires entering Kouri Richins Realty's account, the account balance was negative $1,996.68. As soon as the first wire entered the accounts and before the second wire entered the accounts, the defendant transferred $19,299 of her best friend's down payment to her personal AFCU account to cover a wire transfer of exactly $19,299 to FundFi, an entity in which the defendant had taken out high interest accounts and receivable loan unrelated to that property. By January 19, 2022, the defendant had spent the remainder of her best friend's $45,000 down payment on expenses unrelated to 299 East 100 South, that property. I just lost my place. Bear with me. Okay. On January 19th, 2022, Kouri Richins Realty's account balance was $227.69. The 299 East 100 South refinancing did not take place in January 2022. The defendant was forced to enter into an extension agreement with the largest of the 4 hard money lenders on January 26th, 2022. The 30-year, got distracted. 2022. The 30-year mortgage lender revoked the proposed loan in mid-February and offered less affordable terms. The defendant was thus forced to enter into another extension agreement with the largest hard money lender on February 16, 2022. The unpaid principal on that date was $347,715.86. Okay, I'm losing my place here. There we go. Crazy. Okay, sorry. My document is jumping around again. Okay. And the extension agreement extended on the repayment term to March 8th, 2022. 4 days, I'm assuming, after Eric Richins' death. Ultimately, one of the defendant's lenders foreclosed on the property and evicted the defendant's best friend and her family. The defendant, next subcategory, the defendant submitted a falsified insurance application on Eric Richins' life, count 26. On January 29th, 2022, the defendant applied to TrueStage for an insurance policy on Eric Richins' life with a death benefit of $100,000, and the defendant named as the beneficiary. This life insurance policy became effective on February 4th, 2022, 10 days before the defendant's attempt on Eric Richins' life and 1 month before Eric Richins' death. The defendant was able to apply for the policy because of her membership in PenFed Credit Union. Eric Richins had no affiliation with PenFed. The policy premiums were deducted from Kouri Richins Realty America's First account. Eric Richins had no affiliation with this account. The address for Eric Richins provided on the application is a P.O. box solely belonging to the defendant. The phone number for Eric Richins provided on the application contained an incorrect digit. The signature on the application that purported to be Eric Richins' signature is a forgery. Oof. Next subcategory, the defendant attempted to murder Eric Richins for pecuniary gain, count 26. The defendant occasionally employed Hayden Jeffs to assist her with renovating houses. On January 20, 2022, the defendant text messaged with Mr. Jeffs, "I did want to chat with you about something super random. Not now at kids' stuff. I'll call you tomorrow if that works." On January 21, 2022, at 7:24 p.m., the defendant text messaged Mr. Jeffs, "Hey, today snuck away from me. Can I give you a call in the morning around 11:30? On January 22nd, 2022, at 11:06 a.m., the defendant text messaged Mr. Jeffs, "Got a sec?" Mr. Jeffs told law enforcement that he spoke with the defendant on January 22, 2022, and that the defendant asked him for fentanyl. The defendant told Mr. Jeffs that she wanted the fentanyl for a client who had back pain. Mr. Jeffs told the defendant that he would not get her fentanyl, and the defendant hung up on Mr. Jeffs. On January 22, 2022, at 5:35 p.m., after the phone call in which Mr. Jeffs declined to get fentanyl for the defendant text messaged with Mr. Jeffs, "Have another one for you. Call me if you get a sec." Mr. Jeffs told law enforcement that during a second phone call with defendant on January 22, 2022, the defendant asked him for I cannot pronounce this, propofol. Sorry. Phew. Sorry about that. Mr. Jeffs told the defendant that he could not get her propofol. I don't know why I have never been able to say that word. My apologies. The text messages from January 22nd, 2022, between the defendant and Mr. Jeffs were manually deleted from the defendant's phone. After that date, the defendant and Mr. Jeffs did not communicate ever again. The defendant and Mr. Jeffs had communicated regularly throughout the prior year. On May 31st, 2022, approximately 3 weeks after the defendant's arrest for the murder of Eric Richins, the defendant's mother text messaged the defendant, "Mr. Jeff's running his mouth." The defendant occasionally employed Carmen Lauber to clean houses. Ms. Lauber told law enforcement that sometime in early 2022, before Eric Richins' death, the defendant either called or texted her to ask that she procure some fentanyl for the defendant. Forensic analysis of Verizon's records for the defendant's cell phone show 746 SMS messages, 94 MMS messages, and 12 calls between the defendant's phone and Ms. Lauber's phone between January 1, 2022 and March 15, 2022. These messages were manually deleted from the defendant's phone. The defendant's phone contained messages to and from Ms. Lauber before and after this time frame. Ms. Lauber told law enforcement, pursuant to the defendant's request for fentanyl, she contacted Nicole Cummins for an introduction to someone that would sell her fentanyl. Ms. Cummins confirmed that Ms. Lauber asked her for an introduction to someone that would sell Ms. Lauber fentanyl. Ms. Cummins elaborated that Ms. Lauber messaged her through Facebook asking to speak with her and that she called Ms. Lauber shortly thereafter. The Facebook message from Ms. Lauber to Ms. Cummins on February 5th, 2022 at 1:37 p.m. asked, "Text me, I've got a question, won't do it on this." In response to Ms. Lauber's inquiry, Ms. Cummins provided Ms. Lauber with the phone number of a fentanyl dealer, Robert Crozier. Ms. Lauber's phone contains a contact for Mr. Crozier's phone number. The contact is labeled in a fashion that connects Ms. Cummins with Ms. Crozier. It could be Crozier. I'm not sure what the origin of this name is, but it's Crozier. Ms. Lauber told law enforcement that she contacted Mr. Crozier shortly after receiving his contact information from Ms. Cummins and asked to purchase fentanyl. Ms. Lauber's phone records established that she text messaged Mr. Crozier on February 10th, 2022 at 8:52 p.m. Ms. Lauber told law enforcement that she met Ms. Crozier at the Maverick gas station in Draper on February 11th, 2022, and purchased from him 15 to 30 round light green-blue pills, which she understood to be fentanyl. Ms. Lauber's phone data showed that she called Mr. Crozier several times on February 11th, 2022, between 5:19 and 6:52 p.m. Ms. Lauber stated that these calls were to coordinate the specific timing of the fentanyl purchase. Ms. Lauber's phone data also shows that she text messaged Mr. Crozier several times beginning at 7:18 p.m. while she was located at the Maverick. Ms. Lauber's phone data shows several text messages between the defendant and Ms. Lauber on February 11th, 2022. The messages began at 3:42 p.m. while Ms. Lauber was at her home in Heber and continued at 6:23 p.m. as she passed through Linden on her way to the Maverick gas station in Draper. The defendant and Ms. Lauber text messaged at 7:18 while Ms. Lauber was located at the Maverick and text messaging with Mr. Crozier. The messages continued at 8:20 p.m. as Miss Lober passed through Lehigh on her way back home in Heber and concluded at 8:56 while Miss Lober was at her home in Heber. Miss Lober told law enforcement that she delivered the pills that she purchased from Mr. Crozier to the defendant in a hand-to-hand transaction in the driveway of Miss Lober's home in Heber on either February 11th or February 12th, 2022. Miss Lober's phone data shows that in addition to the text messages to the defendant and Miss Lober's exchanged on February 11th, the defendant and Miss Lober's exchanged the text messages on February 12th. At 9:58 a.m. and 2:49 p.m. Sorry about that. Miss Lober was located at her home in Heber during both exchanges. A certain diner in Camas, Utah, the diner, opens daily at 7 a.m. and at 8:53 a.m. on February 14th, 2022, the defendant placed a 1-minute phone call to the diner. The defendant's and Eric Richins' joint bank account shows a $41.29 purchase at the diner on this day. At 9:41 a.m., the defendant text messaged her paramour, headed up that way. At 9:49 a.m., the defendant text messaged him a screenshot of a navigation application on her cell phone showing her current location on SR 32 in Kansas, and her projected arrival at an unknown destination at 10:49 a.m. At 11:09 a.m., Eric Richins placed a 2-minute call to the defendant. At 11:27 a.m., Eric Richins text messaged a photograph to the defendant. That photograph has been deleted from both the defendant's and Eric Richins' phones. At 11:33 a.m., Eric Richins text message to the defendant, I'm going to go lay down for a bit, but if I don't start getting better, I'm going to head to the hospital. 1 minute later, the defendant responded, geez, is it that bad? Need me to come home? Go take a nap and call me when you're up. 5 minutes later, at 11:39 a.m., activity recorded on Eric Richins' phone and associated devices ceased. Activity did not resume until nearly 2 hours later at 1:32 p.m. At 1:49, at 1:43 p.m., Eric Richins text messaged the defendant and asked, "Are you home?" The defendant responded, "No, in Provo, waiting for my cabinet installer guy. Are you home?" At 1:45 p.m., Eric Richins responded, "In the office, I've been sleeping out here." Eric Richins' office was a freestanding structure behind his home. At 1:59 p.m., Eric Richins called Kouri Wright, a close friend. Mr. Wright could hear fear in Eric Richins' voice and tell that Eric Richins was scared. At 2:11, Eric Richins called Josh Kays, another close friend. Mr. Kays was struck by the tone of Eric Richins' voice and that he seemed different, down, and somber. Opioids, including fentanyl, can cause allergic and pseudo-allergic reactions to include hives. Eric Richins did not have any food allergies. The defendant and Miss Lober exchanged 30 text messages on Valentine's Day 2022. On June 18, 2022, 3.5 months after Eric Richins' death, the defendant text messaged her best friend about this incident. The defendant wrote, "It was Valentine's Day, and Eric and I were both working from home that day, and I ordered him lunch from the diner," with tons of exclamation points. "He never broke out in hives or used an EpiPen. I was effing with him. He said the sandwich hurt his stomach, so he was going to take a nap. No hives, no EpiPen." On August 22nd, nearly 4 months after the defendant was arrested for the murder of Eric Richins, the defendant discussed this incident in 2 phone calls. In a phone call with her mother, the defendant confirmed that she was the person who picked up the sandwiches from the diner on Valentine's Day. She said, "We ate in the office." In a phone call with her brother, the defendant discussed buying lunch at the diner that day. Subcategory: the defendant murdered Eric Richins. Eric Richins for pecuniary gain. Sorry, count 26. Miss Lober told law enforcement that late February 2022, the defendant told her that fentanyl pills that she previously provided were not strong enough and asked that she procure some stronger fentanyl. Miss Lober initially stated that the defendant specifically asked for some of the Michael Jackson stuff during the second request for fentanyl, but subsequently concluded that the defendant may have referred to Michael Jackson during her earlier requests for fentanyl. Michael Jackson died of a propofol overdose, which I can never pronounce. My apologies. On February 26th, 2022, Miss Lober sent Miss Cummins a Facebook message asking that Miss Cummins again provide her with Mr. Crozier's phone number. Later that same day, Miss Lober contacted Mr. Crozier and arranged to purchase additional fentanyl from him at the same Maverick gas station in Draper. Ms. Lober's phone data shows that on February 26, 2022, beginning at 2:25 p.m., the defendant and Ms. Lober exchanged several text messages. They continued to exchange text messages between 5:01 p.m. and 10:22 p.m. as Ms. Lober traveled from her home to Heber to the Maverick gas station in Draper and back to her home in Heber. Ms. Lober's phone data also shows that she exchanged text messages with the defendant, Mr. Crozier, while she was located at the Maverick. At 3:21 a.m. on March 4th, 2022, the defendant called Summit County Dispatch and reported that her husband, Eric Richins, was not breathing. He's cold. He doesn't have a pulse. 10 minutes later, Summit County Emergency Medical Services personnel and sheriff's deputies arrived at Eric Richins' home. They found Eric Richins on the floor at the foot of his bed and performed life-saving measures, but ultimately declared him deceased at 4:58 a.m. And EMS personnel thought that he'd been dead a while and noted that he was asystole at the whole time. While EMS personnel were attending to Eric Richins, the defendant told law enforcement that she and Eric Richins had a drink together at 9 to celebrate something at work tomorrow. A year later, the defendant told law enforcement, "I made Moscow mules in the kitchen and I brought them into our bedroom." The defendant further said that they drank the Moscow mules sitting on the bed. Sometime after Eric Richins' death, the defendant wrote in a journal that on the night of Eric Richins' death, she and Eric Richins went into the kitchen and both started grabbing ingredients for a Moscow mule and a lemon drop. We finished talking and made our way back to our bedroom and brushed our teeth. A pathologist at the Office of Medical Examiner performed an autopsy on Eric Richins and concluded that his immediate cause of death was drug intoxication, fentanyl. The OME determined that the level of fentanyl in Eric Richins' blood was 15 ng per ml, which is approximately 5 times a lethal dose. That his gastric fluid contained an additional 20,000 ng ml of fentanyl. The OME determined that the byproducts of the fentanyl found in Eric Richins' gastric fluid were typical of illicit fentanyl, not medical grade fentanyl. The OME determined that the fentanyl found in Eric Richins' body had been orally ingested. The OME also found 16,000 ng/ml of quetiapine. I'm sorry, I should have looked this up ahead of time. Where am I? I need to make this a little bigger because I can't see it. Quetiapine in Eric Richins' gastric fluid. Quetiapine is an atypical antipsychotic medication used for the treatment of schizophrenia, bipolar disorder, and major depressive order. It's widely used as a sleep aid due to its sedating effect. The defendant told law enforcement at the time of Eric Richins' death she had a prescription for quetiapine. On the night of Eric Richins' death, the defendant told law enforcement, "We eat gummies. Sometimes Eric will eat a gummy before he goes to bed." It didn't seem like he did, though. A year after Eric Richins' death, the defendant told law enforcement that she saw Eric Richins take a THC gummy in the bedroom before drinking the Moscow Mule. The defendant then clarified, "I didn't actually see him take it. He told me he took it. And then he had to have taken it while I was making the drinks." In explaining to law enforcement how the defendant thinks the fentanyl got into Eric Richins' body, the defendant said, "I honest to God think it was one of those gummies. 100%. After the defendant's arrest for the murder of Eric Richins, the defendant's mother asked the defendant if she was sure the fentanyl came from a THC gummy. The defendant replied, "That is what I'm banking on. Yes, the OME did not find any THC in Eric Richins' blood or gastric fluid. The state toxicology lab tested the THC gummies in Eric Richins' home at the time of his death and determined they did not contain fentanyl." The defendant told law enforcement that she went to bed with Eric Richins in the bedroom approximately 9:30 to 9:45 p.m. on March 3rd, 2022, and shortly thereafter went to one of their children's bedrooms to sleep with the child because the child was having nightmares. The defendant said she awoke in the child's bedroom at approximately 3 a.m. on March 4th, 2022, and returned directly to the bedroom. The defendant said that she was asleep in the child's bedroom the entire time. The defendant told law enforcement that when she left their bedroom at approximately 9:30 or 9:45 to go to the child's bedroom, she left her cell phone plugged next to her bed and did not take it into the child's bedroom. The defendant told law enforcement that upon returning to their bedroom, she felt Eric Richins and he was cold to the touch and not breathing, and she immediately called 911. Summit County Dispatch received her 911 call at 3:21 a.m. on March 4th, 2022. Forensic analysis of the defendant's cell phone shows that it was unlocked 6 times between 3:06 a.m. on March 2022 and 15 minutes later at 3:21 a.m. when the defendant called 911. This analysis also shows that in the 13 minutes between 3:08 and 3:21 a.m., the defendant's phone or an associated device traveled approximately 378 feet. The defendant used several cell phones, including burners. The cell phone that the defendant primarily used leading up and shortly after Eric Richins' death indicates a significant amount of information was manually deleted from it, particularly between January and mid-March 2022. Forensic analysis of one of the defendant's cell phones shows that by April 16, 2022, 3 days after law enforcement first informed the defendant that Eric Richins died of a fentanyl overdose, the defendant's cell phone was used to access website articles with the following titles, among others: Utah State Prison, Tampico Timpanogos Women's Facility. What happens to deleted messages? Cause of death usually does not impact life insurance payment. How do police and forensic analysis recover deleted data from phones? And signs of being under federal investigation. Forensic analysis of that same cell phone shows that by June 6, 2022, the defendant's phone was used to conduct the following internet searches, among others. Can you delete something is very misspelled here. Can you delete ever off an old iPhone without actually having it? Women, Utah prison. Can cops uncover deleted messages, iPhone? Can cops force you to do a lie detector test? If someone is poisoned, what does it go down on death certificate as? How long does life insurance companies take to pay? What is a legal dose of fentanyl? I'm not laughing at the subject matter. This is all terribly misspelled and yes, it's hard to read. Okay. Continuing on. On May 8th, 2023, the defendant was arrested for the murder of Eric Richins and received a copy of the charging documents and probable cause statement. The probable cause statement referred to Ms. Lauber by her initials and contained many of the facts presented above. On a jail call that day with her mother and brother, the defendant said, Eric Richins asked me to ask Ms. Lauber for pain pills. The defendant never mentioned asking for pain pills for Eric Richins from Ms. Lauber during the 3 hours of police interviews, and indeed insisted that Eric never took illicit drugs or pain medication other than occasional over-the-counter pain medication. Subcategory: the defendant fraudulently claimed insurance benefits from Eric Richins' death, count 26. The defendant was a beneficiary of 2 insurance policies on Eric Richins' life issued by TruStage with an aggregate death benefit of $350,000. One of the policies issued on May 12, 2017, and the other on February 4th, 2022, 1 month prior to Eric Richins' death. On April 28, 2022, the defendant submitted a claim against the policies. On June 7, 2022, TruStage learned that Eric Richins' cause of death was drug intoxication, fentanyl. On June 14, 2022, TruStage left a voicemail with the defendant requesting a copy of any prescription Eric Richins had for fentanyl. Later that same day, the defendant informed TruStage that the fentanyl was not prescribed and that she didn't have any idea how Eric Richins obtained the fentanyl. On the next day, June 15, 2022, the defendant reiterated to TruStage that she really did not know where Eric Richins obtained the fentanyl. Subcategory: pattern of unlawful conduct, count 26. The pattern of unlawful conduct is predicated on the offenses charged in counts 1 through 25 above, and herein uncharged insurance frauds, attempted aggravated murder, and attempted murder offenses. I believe that is the last page. Yes, that is the last page, and this is signed by Margaret Olson and Brad Bloodworth, who is the chief prosecutor. Whew. Okay, so that is the entire document, and I just see that you are not seeing what I'm seeing on the document. For the entire document, it's odd. For the entire document, I might go ahead and figure out a way to create a digital file, and that I'd be able to upload into the community posts. So just check the community posts if you're looking for the document, or if you want Actually, what I can do is in the description or on the pinned comment, I will post where I got the document and from and credit them for this document. So with that, I'm going to have something to soothe my throat. Hopefully I got most of that right in terms of pronunciations. And I find it fascinating how she's being charged with financial crimes separate from the charge of murder. But if you're watching all of the hearings, you'll understand that a little bit more, why they had to like break that out. There's been so many delays with this trial, but it looks like it will go forward in the beginning part of next year. So this is just another way to prepare us for what's coming for this very important trial if you're interested in this one. And there are so many similarities that I'm seeing between all of these cases. At some point, I'm going to have to take a mental break from all of it. But I know this one is just interesting to a lot of you who are interested in some of the other cases that I've been covering on this channel. It's been a while. I'll be live probably this coming week on some other matters, but if you want more on this, let me know. And even though I'm not live reading, there's no point to it. I am here live. You just can't see my video. I'm sending you love and blowing you kisses, and I miss you all, and I hope to see you more soon. Bye for now.